Hello everyone. This is Shilpi Tyagi, Assistant Professor at IIMT College of Law, Greater Noida. Today we are going to discuss a topic circumstantial evidence. Man may tell lies, but circumstances don't. Initially, we will see what is the meaning of evidence. The word evidence has been derived from the Latin word evider, which implies to show distinctly, to make clear, to view or sight, to discover clearly, to make plainly certain, to ascertain, to prove. According to Sir Blackstone, evidence signifies that which demonstrates, makes clear, or ascertain the truth of the facts or points in issue either on one side or the other. Next, according to Sir Taylor, law of evidence means through argument to prove or disprove any matter of fact, the truth of which is submitted to judicial investigation. Evidence means and includes. Evidence can be divided into two parts, oral evidence and documentary evidence. All the statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, such statements are called oral evidence. All the documents, including electronic records, produced for the inspection of the court, such documents are called documentary evidence. The definition of evidence given in this act is very narrow because in this evidence comes before the court by two means only. The statement of witnesses, which is called oral evidence, and the second is documents, including electronic records, means documentary evidence. Circumstantial evidence is a very tricky thing answered by Holmes. Evidence, direct evidence. Direct evidence is evidence of a fact based on a witness' personal knowledge or observation of that fact. A person's guilt of a charged crime may be proven by direct evidence if standing alone. That evidence satisfies a judge beyond a reasonable doubt of the person's guilt of that crime. Circumstantial evidence. Circumstantial evidence is direct evidence of a fact which applied indirectly, from which a person may reasonably infer the existence or non existence of another fact. A person's guilt of a charged crime may be proven by circumstantial evidence if that evidence, while not directly establishing guilt, gives rise to an inference of guilt beyond a reasonable doubt. Circumstantial evidence is evidence of circumstances which can be relied upon not as proving a fact directly, but instead as pointing to its existence. Circumstantial evidence is based largely on inference and uses inductive reasoning. Example of circumstantial evidence. X is suing his wife for a divorce, claiming she is having an affair with Z. Z fingerprints are found on a book in X and Y bedroom. A judge may infer that Z was in the bedroom. The fingerprints are circumstantial evidence of Z's presence in the bedroom. Circumstantial evidence is indirect evidence that require inference reach a conclusion. Here are some examples of circumstantial evidence, which are as evidence of motive, evidence that establishes the defendant's motive for committing the crime. For motive, we can consider Section 8 of Indian Evidence Act. Evidence of opportunity, evidence that the defendant had the opportunity to commit the crime. In respect of opportunity, we can consider Section 7 of Indian Evidence Act. Evidence of a state of mind, evidence of the defendant's state of mind when the crime was committed. For the state of mind, we can consider Section 14 of the Indian Evidence Act. Evidence of preparation, evidence that the defendant prepared for the crime. For the preparation, we can consider Section 8 of Indian Evidence Act. Evidence of items, evidence that the defendant had items that could be used to commit the crime. Evidence of identification, evidence of the defendant's identification, such as DNA, fingerprints, or mobile phone records. Regarding the identification, we can consider Section 9 of Indian Evidence Act. Evidence of similar crimes, evidence that the defendant committed similar crimes around the same time as the alleged crime, evidence of different versions, evidence that the defendant gave different versions of events. Circumstantial evidence complexity. When we talk about the complexity of circumstantial evidence, so circumstantial evidence is more complex. A witness did not see the stabbing. The witness did see the defendant go into the house carrying a knife. The witness heard a scream inside the house and saw the defendant run out, not carrying the knife. The victim is later found inside with a knife in her bag. A reasonable inference is that the defendant stabbed the victim. Whether the fact is true will determine if the defendant is guilty. Crime scene investigations, the proper recognition, documentation, reconstruction, submission of relevant evidence, and preservation of evidence is critically important in all crimes scene investigations. When we talk about the weightage of the circumstantial evidence, it is a popular misconception that circumstantial evidence carries less weight or importance than direct evidence. This is only partly true. While direct evidence is generally seen as more powerful, more successful, prosecutions rely greatly on circumstantial evidence. Circumstantial evidence often has an advantage over direct evidence because it is more difficult to suppress or fabricate. The law draws no distinction between circumstantial evidence and direct evidence in the terms of weight or importance. Either type of evidence may be enough to establish guilt beyond a reasonable doubt, depending on the facts of the case as the jury finds them to be. Well, in short, we can say that when we rely upon the circumstantial evidence, so it should be beyond the reasonable doubt. Human agency may be faulty in expressing picturization of actual incident, but the circumstances cannot fail. Therefore, many a times it is aptly said that man may tell lies, but circumstances don't. Five golden principles of circumstantial evidence. When we talk about the five golden principles regarding circumstantial evidence, we consider a landmark case law, that is Sharath versus State of Maharashtra, AIR 1984, SC 1622. The circumstances from which the conclusion of guilt is to be drawn should be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency unrailing, pointing towards the guilt of the accused. They should exclude every possible hypothesis except the one to be proved. And there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. These five golden principles constitute the punchil of the proof of a case based on circumstantial evidence. Principle of circumstantial evidence as laid down by Supreme Court in Shanti Devi versus State of Rajasthan. The principles can be set out as under: the circumstances from which an inference of guilt is sought to be proved must be conjointly or firmly established. The circumstances should be of a definite tendency, unerringly pointing towards the guilt of the accused. The circumstances taken cumulatively must form a chain so complete that there is no escape from the conclusion that with an all human probability the crime was committed by the accused or none else. The circumstances should be incapable of explanation on any reasonable hypothesis, same that of the guilt of the accused. Pandala Veera Reddy versus State of Andhra Pradesh, 1989. The principles were retreated as follows: the circumstances from which an inference of guilt is sought to be drawn must be cogently and formally established. Those circumstances should be of a definite tendency, unerringly pointing towards guilt of the accused. The circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability the crime was committed by the accused and none else. Nizam versus State of Rajasthan. In the case of circumstantial evidence, court has to examine the entire evidence in its entirety and ensure that the only inference that can be drawn from the evidence is the guilt of the accused. For establishing the guilt on the basis of the circumstantial evidence, the circumstances must be firmly established and the chain of circumstances must be completed from the facts. The chain of circumstantial evidence cannot be said to be concluded in any matter sought to be urged by the prosecution. The same principles were retreated in Bodhraj versus State of Jammu and Kashmir, 2002, Bharat versus State of Maharashtra, 2003, Jaswant Gir versus State of Punjab, 2005, Reddy Sampath Kumar versus State of Andhra Pradesh, 2005, Deepak Chandrakant Patil versus State of Maharashtra, 2006, State of Goa versus Sanjay Takran, 2007, etc. Burden of proof and circumstantial evidence. In Sharad Birdi Chand versus State of Maharashtra, while dealing with circumstantial evidence, it has been held that the onus was on the prosecution to prove that the chain is complete and the infirmity of lacuna in prosecution cannot be cured by false evidence, by false defense or plea. The conditions precedent, in the words of this court, before conviction could be based on circumstantial evidence must be fully established. In state of Rajasthan versus Thakur Singh, 2014, the lordships of the Honorable Supreme Court in state of Rajasthan versus Thakur Singh have held that in a case of unnatural death of wife of accused in a room occupied only by both of them when there was no evidence of anybody else entering the room and the accused has not explained the circumstances about unnatural death of his wife. The principle under Section 106 of the Evidence Act 1872 was clearly applicable. Circumstantial evidence and corroboration. Circumstantial evidence is a collection of facts that, when considered together, can be used to infer a conclusion about something known. Circumstantial evidence is used to support a theory of sequence of events. The sum total of multiple pieces of corroborating evidence, each piece being circumstantial alone, will an argument to support how a particular event happened. In civil and criminal investigations, corroboration is often supplied by one or more expert witnesses who provide forensic evidence. Circumstantial evidence is usually a theory supported by a significant quantity of corroborating evidence. The circumstantial evidence, being totally based on circumstances necessarily required to be established by the prosecution only by way of corroborating circumstances surrounding by the event or offense, and thus viewed corroboration is an integral part of such type of evidence. Evidence as a sole basis of conviction in Ramavati Devi versus State of Bihar, wherein it has been held as follows: what evidentiary value or weightage has to be attached to such a statement must necessarily depend on the facts and circumstances of each particular case. In a proper case, it may be permissible to convict a person only on the basis of dying declaration in the light of the facts and circumstances of the case. In the last, we come to the conclusion: circumstantial evidence, though indirect, builds a case by linking related facts requiring interpretation to infer conclusions, while it lacks the directness of first hand accounts. Multiple pieces can combine to create a possessive narrative, especially when alternative explanations are unplausible. Such evidence, when sufficiently corroborated, can decisively support a verdict as it often provides a coherent picture of event. Therefore, circumstantial evidence is valuable in the legal process, sometimes proving as strong as direct evidence. Thank you.